Well, welcome back to Judicial Ways of Working, the podcast series produced by the Institute for Advanced Legal Studies at the University of London. My name is Carl Stychin, and I'm the director of the Institute. This series explores how members of the judiciary are working during the global coronavirus pandemic. It's a great privilege to welcome Lord Lloyd-Jones of the UK Supreme Court to today's podcast. Lord Lloyd-Jones was born and raised in Pontypridd, Glamorgan, Wales, where he attended Pontypridd Boys Grammar School. He studied law at Downing College, Cambridge, and was a fellow there from 1975 to 1991. As well as his career as an academic, he was a successful barrister, and his practice at the bar focused on international law, EU law, and public law. He was made Queen's Counsel in 1999. Lord Lloyd-Jones was appointed to the High Court in 2005. From 2008 to 2011, he served as a presiding judge on the Wales Circuit and chair of the Lord Chancellor's Standing Committee on the Welsh Language. In 2012, he was appointed a Lord Justice of Appeal, and from 2012 to 2015, he was chair of the Law Commission. In 2017, Lord Lloyd-Jones was appointed a Justice of the Supreme Court. He is the first member of the Supreme Court to come from Wales. Lord Lloyd-Jones, welcome to the podcast.
Thank you. Thank you, Carl, and thank you for the invitation to take part in the recording.
Can I begin by asking you to describe your everyday professional life as a Supreme Court Justice as it was before the pandemic?
Well, as you know, the Supreme Court of the United Kingdom is the final court of appeal for the three jurisdictions within the United Kingdom. And the 12 justices who make up the court also sit as the Judicial Committee of the Privy Council, which is the final court of appeal for 27 jurisdictions within the Commonwealth. Now, we usually sit in our premises in Parliament Square in London. However, in the last 3 years, the Supreme Court has also sat in Belfast, in Edinburgh, and in Cardiff. In the Supreme Court, we usually sit as a panel of 5 justices, but on occasion we sit as 7 or 9 justices. On 2 occasions, the 2 Miller appeals, the court has sat as a court of 11 justices. Last year, 2019, the Supreme Court delivered judgments in 60 cases, and the Judicial Committee of the Privy Council delivered judgments in a further 48 cases. We attach particular importance to the accessibility of our proceedings. Attendance at hearings by members of the public is encouraged, and all of our hearings are live streamed on our website.
And to what extent was your judicial role previously enabled by technology prior to the pandemic, which seems a long time ago?
Yes, UK Supreme Court cases have always been heard in person at the Supreme Court building. Prior to the present crisis, we did offer video conferencing as an alternative to a hearing in court in certain appeals to the Privy Council, where time zones were suitable and where the technology was locally available. The Supreme Court has required parties to submit case bundles in both electronic and paper format since 2010, so all of the documentation in appeals is digitalized. And increasingly over the past 5 years, justices have used laptops in the courtroom and have used digitalized documents as opposed to hard bundles. Some of us tend to use a laptop for taking notes, others of us take notes in a notebook. All of the Supreme Court and Privy Council cases are recorded and they're live streamed, so people can watch the court at work in real time or on demand.
And how has work changed for you and your colleagues as a result of the pandemic? And how was that change managed?
The Supreme Court held its last hearing in court on Tuesday the 17th and Wednesday the 18th of March. And it became evident during that week that considerations of safety for court users, court staff, and the justices were likely to make it impractical for us to continue holding our hearings in the conventional way. The Supreme Court IT staff worked very hard over the next few days to set up the technology required for the court to continue to operate while the staff and justices were working from home. And in relation to hearings, they set up WebEx software on the laptops of the relevant staff and justices, and we connected it to our live stream so as to maintain public access to the hearings, which was regarded as being vital. Training was then given in the use of the technology. We had some rehearsals, and we were able to hold our first virtual hearing on Tuesday, the 24th of March. Since then, we have continued holding hearings by that means. The transition has, I think, been relatively smooth, although we have had to adjourn some Supreme Court hearings where counsel fell ill shortly before the appeal was due to be heard. And some appeals to the Privy Council have also had to be adjourned because of other local problems. Pre-court discussions among the justices and deliberations following the conclusion of a hearing also take place online. We've continued to deliver judgments as usual. Generally, we pre-record the explanation given to camera by one of the justices, and then we live stream the recording. During this time, two new justices, Lord Leggett and Lord Burrows, have been sworn in, that is, during the lockdown. Swearing-in ceremonies usually take place in courtroom 1 and are attended by many members of the legal community as well as by friends and family of the new justice. However, because of the lockdown, we couldn't do that, so the two new justices had to take their oaths in the presence of our President Lord Reed in the library at the Supreme Court, while the rest of us, all the other justices, took part remotely via video conference. There is, of course, a great deal of other work involved in operating the court. For example, processing and deciding applications for permission to appeal, and there are other applications to the court that can be decided without an oral hearing. That has continued using video conferencing and teleconferencing in place of face-to-face meetings between the justices.
So how are you managing the new reality of judging at a distance? Are there particular challenges that have arisen?
Well, in terms of the mechanics of the hearings, we've developed a number of protocols. Prior to the hearing, in advance of the hearing, it's necessary to book separate meetings for the justices' pre-hearing discussion, for the morning session of the hearing itself. That involves counsel and the IT team from about 10 o'clock, with the justices joining about 10:20 to iron out any problems before the hearing starts at 10:30. Then we have to book a separate meeting for the afternoon session and another separate meeting for the justices' post-hearing conference. If there's a possibility that the panel might not need to hear the respondent or might want to limit the matters which the respondent needs to address, a further meeting can be organised at the time when the appellant's counsel is scheduled to complete submissions or during the short adjournment so that we can discuss those matters. Before starting the hearing, the presiding justice asks the broadcasting team who are listening in if they're ready. When they are, they tell him, and so far the presiding justices have been men, that they will then start broadcasting in 10 seconds. The presiding justice then introduces the hearing and gives the names of the main parties to the appeal. He will explain that the appeal is being heard remotely with each participant sitting in a different location in accordance with the government's instructions in response to the COVID-19 crisis. He asks for patience if we encounter difficulties to allow the IT team to resolve them. He explains that the footage of the day's hearing should be available on the court's website within 48 hours. He then explains that to reduce interference or echoes and to prevent the camera from being attracted away from a speaker, the IT team hosting the hearing have been asked to keep muted the microphones of everyone other than the person speaking at the time. Then tells the participants in the hearing that if they wish to speak while someone else is speaking, they should indicate by raising their hand so that, first of all, the speaker can see them and pause, and secondly, the IT staff can unmute their microphone. And a person wishing to speak will see when he or she has been unmuted as the mute icon on the screen of the laptop will go off. He then introduces each member of the court, inviting each of them to raise a hand when their name is called, and the judge's image is displayed when they're named. And finally, the appellant's counsel is invited to introduce counsel and to proceed with the appeal. We have found that online hearings can be more tiring than ordinary hearings, and we've therefore decided to introduce a short mid-morning adjournment as well as the usual adjournment for lunch. Now, I think that the online hearings have overall been a considerable success. They've certainly enabled us to keep the show on the road. Nevertheless, we are conscious that people watching a virtual hearing have a different experience from watching a live stream of a real court sitting. There's not the same spontaneity of interaction between the participants as in a real court, and the viewer can't see anyone other than the person who's speaking at that particular time. There's no opportunity to see the whole court.
Are there aspects of the changes that you actually prefer that might even be improvements to the ways in which the court works?
Yes. A new online filing system based on SharePoint has been set up to allow the parties to submit case bundles, applications, and other papers online or via email. Now, previously, this would all have been done on paper, either delivered to the court by hand or posted. So that's really been a big step forward in terms of digitizing that process. All of the justices can now access the case bundles they require electronically, and that's been crucial in allowing the justices to prepare for the hearings and to hear cases remotely. Previously, some of the justices worked digitally, but most of us relied on paper bundles.
And by contrast, have there been aspects of remote working that give you concern, and how have these been managed?
Well, in introducing remote hearings, we've been very anxious to ensure that the court's proceedings remain accessible to the public. So the live streaming of these hearings has been absolutely vital in ensuring that members of the public are able to observe the hearings as they take place. A number of technical problems have been encountered, certainly in the initial hearings, but we've learnt a lot from these. So far as muting is concerned, some problems arose at the first hearing as a result of a microphone being unmuted, although the person wasn't intending to speak. Shuffling through the papers or typing, for example, would result in that person appearing on the screen. That's been resolved by the IT team controlling the microphones of every participant at the hearing. Then there's the positioning for the cameras and the question of backdrops. The IT team send conference call guidance to counsel in advance of the hearing, and the justices follow the same guidance. There is, of course, an absence of contact between counsel who are addressing us and their own legal teams, or a limitation of contact anyway. Now, we've adopted a flexible approach here to allow post-hearing submissions, as counsel addressing the court have not had the simultaneous contact with their legal teams and their expert advisors that they would normally have when they're in court. And we've sought to address that by encouraging counsel to have contact with their team via another laptop or a phone.
Assuming that at some point things go back to some form of normal, but sometimes called the new normal, do you think that there are lessons that can be learned from this time as to how we resolve disputes in the future? What has this experiment taught you about remote working?
Well, I'm sure that the hearing of at least some cases in the Privy Council via video conference will continue. No decision has been made about whether we will continue to use online hearings in the Supreme Court, once the present crisis is over, either routinely or in exceptional situations. Online filing for parties, on the other hand, is likely to continue, and I think it's very likely that a number of my colleagues will opt to continue to use digital bundles. We're likely to continue using video conferencing and teleconferencing for meetings, which can conveniently be held by that means. We are, of course, a United Kingdom court, so we often have meetings involving people from Scotland, England, Wales, and Northern Ireland, which can more conveniently be held using video conferencing or a conference call than by requiring the participants to travel.
And finally, remote working is a challenge for many of us. And of course, we're all differently positioned in terms of those challenges. Do you have any advice for those who are finding it difficult to work remotely?
Well, I wouldn't presume to give advice, Carl, not least because I wouldn't claim to have any expertise in IT matters. So I'm the last person to be giving advice to others. But what I can say is that we've been very fortunate in that first-class technology, the expertise of our technical staff, the efforts of staff in our registry, and the cooperation of the court users have all enabled us to continue to perform our functions effectively and with a minimum of disruption. And for that, my colleagues and I are all hugely grateful.
Well, Lord Lloyd-Jones, thank you very much for joining us today and for sharing your insights on judicial ways of working. Thank you very much.
It's been a great pleasure. Thank you.